Chapman versus Chapman.
Thank you. Mr. Brown?
Good morning. May it please the Court, my name is Phil Brown, and I'm here on behalf of the appellants who are the owners of the property at issue in this case. What we're here for today is really four issues that we'd like to bring in front of the Court. The first is that we'd like the Court to reinstate the trial judge's declaration that the lease in this case be terminated. The second issue that comes before the Court follows from that, and that is what happens as a result of this material breach and the termination of the lease. That is, are the appellants entitled to use and occupancy, or are they entitled to get back the ill-gotten gains of the rent paid? And then the third is whether or not the appellants are entitled to their attorney's fees under 93A.
Could you help me out a minute, please? Is there a definition of trade fixture in the UCC?
I don't know, Your Honor.
Okay. I don't either. And is the ATM kiosk, it's not attached to the building, I gather?
No, the ATM kiosk is centered in the middle of the parking lot, and it's essentially a canopy with the ATM kiosk underneath, much like a gas station pump.
And it can be removed without damaging the landlord's property, is that right?
Well, I think the kiosk, the actual ATM machine certainly can be taken out.
The bolted-down machine, I assume.
It is, but it's on a concrete pad. It has a canopy over top of it.
Well, let's separate the two things out. The ATM is, wouldn't you agree the ATM itself is clearly a fixture and not a structure?
I would agree that the ATM, the actual machine itself, is a fixture.
So it's the canopy you're complaining about, which is
Well,
on
I think it's
stakes or poles or something?
I think it's the entire thing. It was built as a canopy, pad, ATM kiosk all together.
Ask you, assume for the moment that you're correct, that some or all of this thing should have been treated as a structure. How was the landlord reasonable in withholding consent? It looks like, and I haven't read the whole record from the briefs, but all the reasons that the landlord gave for not consenting to this had nothing to do with the kiosk, but were centered around the change in use from a retail store to a bank, something that the landlord had no grounds to or no say in. Where is there some reasonable basis for an objection to the ATM kiosk and canopy itself?
I think, Your Honor, if you'll take a look at Patty Mahar's testimony, which is included in the record, and it's true that there was certainly testimony as to the nature of the change in use of the property, but there was also testimony as to the change that results to the property as a result of the kiosk. For example,
what was it? Yeah.
There are curb cuts that had to be installed. There is a aquifer sprinkler system that has to be maintained in perpetuity, even after the bank leaves the property.
Excuse me, in perpetuity?
That's what the variance, that's what the zoning board required. There's also, and I think this is reasonable, the owners were concerned about increased liability as a result of the kiosk. They were concerned about visibility issues, traffic issues, all the sorts of things that an owner of property might be concerned about with the installation of a kiosk on.
And didn't the bank address certainly the most serious, or perhaps even the only serious objection, namely the potential for increase in liability by a significant increase in their insurance coverage and the naming of your clients as being covered by that policy?
They certainly included the owners as part of the insured, but I think that the fact that the owners didn't have the opportunity to even address the zoning board on these other issues of traffic, concerns over the nature of having an ATM on your property, that sort of thing.
If the sprinkler system were not maintained in perpetuity, what would befall your client? The variance would lapse?
No, I think what could happen is that the building inspector could bring an enforcement action against them. Or if they want to get rid of that, they're going to have to go in front of the zoning board and ask that the variance be withdrawn.
Mr. Brown, help me out here. Are we interpreting paragraph 9 of the lease?
Well, frankly, Your Honor, it's our position that paragraph 9 really has nothing to do with paragraph 8. Paragraph 9 defines what stays with the property and what can be taken from the property at the termination of the lease. Paragraph 8 is very different. It defines what the lessee can do at the outset of the lease. That is, the lessee has the right to act as the attorney in fact for the owners to seek variances for what was defined as the original construction. Once that original construction was finished, then if the lessee wanted to put further structures on the property, they had to go back to the owners and ask for consent, and the consent cannot be unreasonably withheld.
Could you help me out a little bit? There's probably an obvious answer to this, but this was tried to a jury, was it not?
Yes, it was.
Was the question put to the jury whether this kiosk was a structure or a trade fixture for them to determine?
No, the questions that went to the jury were, first of all, was consent unreasonably withheld with respect to the ATM kiosk? And then the second question was whether or not the lessee committed a material breach of the lease. And that wasn't limited or defined, at least in the jury verdict questions.
But to answer one or both of those questions, didn't the jury have to determine whether this was a trade fixture or a structure?
It was certainly argued to them, wasn't it?
It was argued to them.
It was argued to them that it was a structure, and in fact, in the jury...
Well, because if you're going to rely only on paragraph 8, correct, so you're telling me paragraph 9 doesn't apply, I don't have to decide whether it's a trade fixture perhaps, but I have to, paragraph 8 only goes to future buildings, right, or structures. So I can determine that the ATM and the concrete pad, not I, the court can determine that the ATM and the concrete pad is not a structure within the meaning of paragraph 8. It may also not be a trade fixture within the meaning of paragraph 9. I may agree with you that that's just irrelevant, provided that it's not a building. There's no claim by your client that this is a building, is there?
No claim that it's a building. It's a claim that it's a
you're
structure.
only claiming that it's a structure.
I'm asking a more basic question. If you people tried this case to the jury and to have them decide whether this is a trade fixture or a structure and answering those questions you were talking about, it was argued to the jury. I assume the judge gave some sort of instructions on those two concepts?
What the judge did is, at least in the pre-charge phase of the case, the judge was of the view that a trade fixture could be a structure. And
well, forget the view. Did he instruct the jury on the difference on what a trade fixture might be? Were you there?
Yes, I was there, and I'm thinking, I don't think she instructed specifically on what a trade fixture is.
Did she instruct on what a structure is?
No, what she did is she instructed on what a material breach was.
Well,
did you ask for an instruction on structure?
We did not ask for an instruction on structure.
But surely if there's a dispute as to whether this thing is a building or a structure, it would be the same as you coming in now and saying, well, this is a building. It's clearly a building. People, can... In other words, if the issue is this isn't a structure, forget what it might be, but this isn't if that's the claim, if this isn't a structure, don't you have to have the jury decide whether this is or isn't a structure?
I think the case was tried from the get-go with the understanding that it was a structure. The question then that was argued to the jury was whether it was a trade fixture, and what the lessee argued is that if it was a trade fixture, then it can't be a structure.
Well, correct.
Surely then the judge had to instruct the jury on the difference between the two. How's the jury going to determine legally what a trade fixture is or isn't, or a structure is or isn't, without some form of instructions?
I don't believe that and perhaps my brother can correct me, but I don't believe that the judge instructed specifically on what a trade fixture or
Well,
a structure
I guess
is.
what I'm leading up to is if, in fact, this went to the jury in some way, shape, or form, with them to determine whether this, as a question of fact, whether this was one or the other of those two things, and proper rights weren't preserved by you folks for, judgment notwithstanding the verdict, all that kind of thing, then this whole case goes down the drain on a procedural point.
I would disagree, Your Honor, because I think that there was certainly evidence in the case and as to what a structure is. There was certainly evidence in the case that under the
jury
zoning...
ruled in your favor.
That's right.
On the issue of material breach.
That's right.
So, could I ask you to move on to a different point? Even with the jury's denominating this a material breach, what is your response to the argument of the defendants that terminating the lease for a breach where the jury found it did no damage whatsoever to the landlord, that terminating the lease under these circumstances would be an inequitable forfeiture?
Well, I think there's two answers to that. First of all, the jury made the determination that it was a material breach, and under the case law, once there's a material breach, the lease should be terminated. But second of all, the jury also made the determination that the defendants engaged in unfair and deceptive acts or practices.
That was with regard to their behavior in front of the town board. That had nothing to do with the kiosk itself in terms of what it did to the property. Their finding is that it to award no damages for any of this, including the unfair and deceptive practice. If there's no damage, it does seem a bit harsh to terminate a long-term lease over something that has caused no damage. You could perhaps, an order to remove the ATM kiosk might have been in order, but why a termination of the entire lease?
Well, I think, Your Honor, if first we argued that there were damages, if you want to consider the rent that was wrongfully paid that should have gone to
the jury found no damages.
Because this was not tried as a damages case. It was tried to seek the termination of the lease.
Well, the jury was asked to decide damages.
We had asked that the damages be the amount of rent that was paid.
And they didn't award that to you?
No, they did not.
They found none, under each theory, none. No damages.
I think, though, with directly to your question, where there is inequitable conduct on the part of the defendants, then I think a forfeiture is certainly warranted. And I can tell you that there is at least some case law in the Superior Court, Justice Kern in the Health South case.
But the cases that you're relying on for a disgorgement all relate to the corporate situation where there's a breach of fiduciary duty. There's no fiduciary relationship in this case.
No, what we're relying on, Your Honor, is that in terms of disgorgement, in terms of use and occupancy, we have various theories which get us to the same place. It's our view.
But you're only entitled to the rent that you could have collected under the lease. Those are
That's correct.
That's what you're entitled to for the occupancy of the premises.
That's correct. And that would be the same under a disgorgement theory, the same under the use and occupancy theory.
Well, but I guess my point is you're not entitled to it unless there's a fiduciary relationship. You're not talking about a situation where you have an agreement with the bank. This is was the lease based upon the net income of the tenant?
No, it was not.
So the rent was not based on that?
No, it was a strict flat rent fee. What we're saying, Your Honor, is that they are not entitled to their ill-gotten gains, that when you can make...
But you're only entitled to it if there's a fiduciary relationship between you and the tenant. If the tenant has misused there's no constructive trust here.
No, I would disagree with that, Your Honor.
Do you have any case law that says...
What we're entitled to is if you assume a material breach, you assume it's and there's a termination, at that point the bank becomes a tenant at sufferance. And as a tenant at sufferance, we're entitled to the use and occupancy of that property. We're entitled to the rent that was paid by the bank to Mr. Katz during that period of time when they're a tenant at sufferance. And I think we cite, certainly the First Circuit in the Dale case goes through all of the Massachusetts case law on tenant at sufferance. And if you take a look at Chapter 186, Section 3, certainly says that we are entitled to use and occupancy for the period of time while the bank is a tenant at sufferance.
Well, the bank was paying, what, $27,000 a year to the holder of the lease?
Yes, that's correct.
And he was in turn paying you $14,000 a year?
Mr. Katz was paying us roughly $1,000 a month, yes.
All right. So you would be entitled to the difference, not to the whole 27, because he was already paying you.
Well, I would say that we're entitled to whatever monies are paid by the bank.
Mr. Brown, could I just ask you this
But
question?
you got half of it from the, I'm sorry, you got half of it from the leaseholder already. I mean, in your damages claim, you have $27,000 per month.
That's
as
correct.
Damages.
That's correct, because that's the amount of rent that was paid. I think that's what the bank was paying for its rent. That's what we're entitled to, is
You were
what the
already
bank
getting
paid.
some rent from the camera
But you already got
company.
it.
We received rent from our lessee, the camera company.
You're saying that...
Whether that rent...
But for the ATM, if the ATM weren't there, they wouldn't be getting anything.
That's correct.
Okay. Could I just ask you this question? And Justice, the appeals court makes clear that from the get-go, the defendants here were saying, look, structure isn't defined, but the one thing that we know in this lease, looking to paragraph 9, that there's a difference between structure and trade fixture. Is there something wrong in the analysis that says if this is a trade fixture, if it is, you don't agree that it is, but if this is a trade fixture, it cannot be a structure?
The reason that analysis is wrong is because when you're looking at variances and zoning issues under paragraph 8, and that's what paragraph 8 addresses, certainly trade fixtures can be structures for which variances are required.
So your basic argument is structure as it's used in paragraph 8 is something different than structure that is used in paragraph 9.
Or that you can't define under paragraph 9 a structure as not a trade fixture, just like you can't define an alteration or an addition as not a trade fixture, which is what the appeals court would have us do.
Okay. Thank you, Mr. Brown.
Thank you.
Mr. Huber?
Good morning. May it please the Court, my name is Evans Huber. I'm here on behalf of the tenant in this dispute, Bank North.
Did your client request an instruction as to the nature of a trade fixture?
My brother, Mr. Moxham, did, and the Court would not allow that instruction.
But the Court allowed you to argue
Well,
the trade fixture issue.
we made our motion back in the summary judgment stage years and years ago that this was not a structure, as that term is used in the lease, and then again around the time of the jury charge. And the judge said, Mr. Moxham proffered an instruction which would have asked the jury to make that finding, structure versus trade fixture, and she did not allow it. She said, well, I'm going to allow you to argue it to the jury, but at that point, I think we were fairly hamstrung.
He submitted a recommended instruction in writing?
I believe that's correct, Mr. Moxham, yes.
And when she declined to give it, did he object?
I'm sure he did. I don't recall offhand, but I'm certain he did. In one of the footnotes in my brief, I cite to the record where he proffered that instruction. I don't remember which.
Could I ask you,
Mr. Huber,
what is your basis for saying that a trade fixture, the terms trade fixture and structure, you are positing those as absolutely mutually exclusive terms? And it seems to me there's all kinds of things that we would view as trade fixtures in the sense of can they be removed without damage, et cetera, for how are things going to be disposed at the end of the lease, but that we would unquestionably view as structures. You know, you have some of those large, they're semi-permanent, but, tents. A big tent that was going to stay up all the time, you would surely view as a structure. And yet, when it came time for the tenant to leave, you can pull the poles out and blah, 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 and off it goes. It becomes a trade fixture. I don't see how the terms are mutually exclusive.
Your Honor, in the general understanding, that's correct. There's no reason why a trade fixture can't be a structure, and if you look at the dictionary definition of a structure, a trade fixture certainly falls within that. Something constructed. Obviously, that's what a trade fixture is, and in fact, the canopy here would fall, that sits above the ATM machine, would fall within the dictionary definition of a structure. But that's not the question. The question is, what's the agreement between the parties? The lease here makes a distinction between trade fixtures and structures. So the question is not...
But only when it comes to that time in the lease where that distinction is of importance, namely what stays that the landlord keeps and what goes that the tenant may take with him.
Right, and you're alluding to...
At the end. Paragraph 8 talks about a completely different problem.
Well, no. Paragraph 9, you're correct in your description of paragraph 9, and then paragraph 8 uses the term structure. So the question is, as a matter of contract interpretation, are you going to give two definitions to the term structure as it's used in lease, or one?
But a trade fixture under paragraph 9 could be construed as a type of structure that could be removed at the termination of the lease.
But that's not what it says, Your Honor.
Well, it could be read that way.
Well, I don't think that's a fair reading of it.
Then why doesn't it say that a piece of furniture can't be removed? When the days when this lease was first written, computers were huge, or you could have showcases inside the store that was being used here that were even bigger than the kiosk. Could they be removed at the end of the lease?
I think the question is whether or not this can be fairly construed as a trade fixture. I think
Can I ask the question slightly differently? Why would one not read paragraph 8 to say a structure, as that term is used in paragraph 8, is something for which you have to get town approval, consent, or permits, and the like? So if you have to get approval, consents, permits, and the like, that's what paragraph 8 is directed towards. I don't know whether you might, in some circumstances, you might need a permit, consent, and the like from the town to put a trade fixture, something that everybody agrees is a trade fixture. You might need permission from the town to put that, but within the meaning of paragraph 8, that's a structure.
You would presumably need it for a big tent.
You might or might not, but you might. I mean, I don't know.
Well, I think the cases that we've cited in our brief basically go to the proposition, Your Honors, that if you're going to use a term in one way in a lease, then you're
I'm using
it
consistently all the way.
Well, I think if you look at paragraph 9, I think the fair interpretation of paragraph 9 is that structure and trade fixture are mutually exclusive terms. They are not the same thing.
For purposes of who gets to own them.
Well, it depends on whether you want to define it narrowly in that way or whether you want to say we are drawing a distinction between trade fixtures and structures. I think it's a reasonable interpretation of paragraph 8 to say the intention of paragraph 8 is to say you can't tear down this building and put up a new building or what most people would think of as a building. But if you're going to put in an ATM machine, which, by the way, is something that nobody knew what it was in 1974 when this lease was entered into, but if you're going to put up an ATM machine or whatever they might have considered a trade fixture back in 1974, you don't have to get our permission. We're not insisting that you get our permission for that.
Clearly, if the ATM machine had been put right into the wall of the building, recessed into it, nobody would argue that it was a structure.
Well, they might have.
I think they would. And in fact, Your Honor,
because they say you have to cut the curb and you have to...
One thing I would like to address, for that, actually, is that Mr. Brown said a moment ago that this whole case was tried on the premise that everybody agreed this is a structure. That's not correct.
No. But it seems to me that the problem was, once it became freestanding with a canopy and all this stuff, it apparently triggered these requirements of the town for a further variance, because they viewed it as a structure for zoning purposes. And paragraph 8 is clearly talking about zoning. It's talking about the original variance that has to be gotten, and that the owner is giving consent to do that, but no other buildings or structures. I don't know the zoning laws of this town that well, but I I would suspect that an ATM could have been put inside the building or recessed into the wall on the exterior of the building, and it wouldn't be a structure, because it still just would have been a modification of the existing building. And I gather extensive renovations were done to the building.
That's correct, Your Honor.
Okay. And the landlord has no say about that.
That's correct. The landlord has no say about that. Your Honors, I notice that my time is just about up. There is one issue that I would like to speak to very briefly, which is not on this question of trade fixture versus structure, but it has to do with an issue which I think may be of interest to this Court, which is this question of whether or not the plaintiffs are entitled to an award of attorney's fees for having identified an unfair or deceptive practice, but no damages. The main point I would like to make very briefly, and I see I'm over my time, is that in the only case which they cite for the proposition that you are entitled to an award of attorney's fees without identifying any loss of money or property is Hanover Insurance Company versus Sutton. And the important distinction between that case and this one is that in Hanover Insurance, the unfair and deceptive act was the act which gave rise to the injunctive relief that the plaintiffs got in that case. In this case, the equitable relief that they are hanging their hat on as a reason why they're entitled to attorney's fees in the absence of damages. The equitable relief they got was termination of the lease, which had to do with the breach of the lease. That had nothing to do with the award, with the supposedly unfair, deceptive conduct. So I think that even if you were inclined to reverse the appeals court on this issue of trade fixture versus structure, they're still not entitled to an award of attorney's fees under 93A.
Thank you.
Thank you.
Mr. Huber. Mr. Moxon?
Good morning, Madam Chief Justice, fellow justices. I represent David Katz, the tenant, the camera company, also. I'll answer Justice Graney's question about the instruction which I requested. The judge made it plain that she thought this thing was a structure as a matter of law. She wasn't going to give the instruction I requested. I was permitted to make my argument to the jury. I did. I lost. I elected that this was not the way to pursue my remedy on appeal.
But what was the instruction that was requested?
I really don't remember because it was
So
never
what
part
you're
of my
saying
appeal.
is that you folks are perfectly satisfied, and we're so at the appeals court, for an appellate court to decide the whole thing is a question of the law based on an interpretation of the lease, and forget what the jury did.
I thought it was a question of interpretation of a written instrument which is for the court. That's what I thought.
Well, apparently everybody agrees on that, correct?
Right. And I thought that under that, as the appeals court did, that where the agreement speaks of structure staying, in paragraph 9, trade fixture being removed, that where in one part of the lease, at least for that purpose, they indicate what's what, it ought to be considered in the same view in the other part. That's what was my view. That was the appeals court's view. That was not the trial court's view. I want to move off this because we've beaten this to death a little bit, unless you have questions of me on structure versus fixture. But one of the points that I think is very important is that the fact that the jury found no damages was equally important, if not more important, than the finding of material breach in the trial court's consideration of what do I do with these findings? Should there be a termination? Of course not. So inequitable to terminate a long-term lease where there's no harm whatsoever. The undisputed evidence was this thing, this ATM kiosk, could be removed simply by unbolting the kiosk from the concrete pad. And the bank offered to remove it.
What would happen to the concrete pad?
Nothing. It was bolted to the concrete.
Yeah, but I mean, the concrete pad then is an impediment in the parking lot.
An existing concrete pad, correct?
Yes. Well, the bank put the concrete pad in the parking lot. It's like an island directing traffic.
Does it sit?
Who cares?
Well, maybe, but it must take up some spot that could otherwise be a parking place.
That's not something about which the owner has a right to complain. They can alter the parking lot any way they want.
They can plant trees there.
They can plant trees.
Or they could remove it.
They can remove concrete pads. They can redirect the flow of traffic any way they want. That's not a structure or a building. The only control that the landlords had over this property was to prohibit, without their reasonable refusal of consent, a structure or a building. They retained that right. They didn't have any control over the sprinklers, over the curb cuts, over how you configure the parking lot, so that when you have an object that is so easily removable at, during, or following the conclusion of the lease, where it has no harm on the landlord, to terminate a 30 or 40-year lease is unconscionable.
Could you have sought a declaratory judgment on that issue before going ahead with the construction?
Yes, of course, I think we could have. I mean, the fact that we could have done something doesn't mean we have to, but you're right, we could have. We also could have invited the landlords to participate in the zoning process. We didn't, but we didn't have to, because sometimes zoning boards say no, and then the issue is not even existing anymore. In this particular case, no damages, no harm. There hasn't been an appellate court in this state ever uphold termination where there's been both no harm and the landlord is fully able to be restored to the status quo with, again, no harm. It's so easy to remove this kiosk and piece of equipment from the parking lot. The tenant thought this thing was a fixture. The bank's lawyer thought this thing was a fixture. The appeals court thought this was a fixture. And this dispute is a bona fide dispute. This wasn't a defiance of the lease by either the bank or the tenant. This was...
No, go finish. I'm sorry.
This was, we think we can do this without your consent. You say we can't. That's totally different from a defiant breaking of the lease or that causes harm. So what I'm saying is it's not the kind of a situation where you terminate the lease.
Did you offer to remove the kiosk in order to avoid the remedy of termination?
No. The only offer to remove the kiosk occurred during the trial and before the trial in a letter from the bank's lawyer where they said, we'll remove it at the end of the lease. But no one ever offered to remove the kiosk or ATM before the term of the lease. One would believe that a reasonable court, the reasonable remedy imposed by a court would be remove that thing because it hasn't caused any harm.
Assuming there's breach.
Assuming there's a breach. And of course, I say, no way was there a breach. And no way was the refusal to give consent reasonable. In my brief, I outlined just what they gave as their reasons for refusing to consent. And the judge correctly charged the jury on this point under the Worcester-Tatnick case. They were concerned about the sprinkler system, had no right to be concerned about that. They were concerned about the change from retail store to bank, had no right to be concerned about that. They were concerned about liability insurance, had no right to be concerned about that, but the bank caved on that point anyway.
Do you agree this was properly submitted to the jury for their verdict?
No way. I filed a motion for JNOV on the grounds of fixture versus...
No, I'm talking about unreasonably withheld.
No way.
It should not have been submitted to the jury whether or not consent was unreasonably withheld?
Because there was no evidence which would support the reasonable withholding of consent. And I argued that in my motion for directed verdict and JNOV. These people, the only reason they did this was so they could get more control over their property and change the terms of the lease, and they admitted it. They admitted it in their testimony and deposition, which was read at the trial, quoted in my brief. That's why they did this. They tried this 4 or 5 years prior and failed. So this was just another attempt to get out of a long-term lease that they didn't like. And we're dealing with second-generation tenant, second-generation landlord. Neither of these parties had anything to do with the execution of the lease. They both inherited it.
Thank you.
Thank you, Your Honors.